Good morning, everyone. Welcome to our webinar. Today's topic is school enrollment contracts and process, opportunities, traps, and tips. And our presenter today is Fiona Manderson. Fiona is our senior counsel with extensive experience in school and education law. And when I say extensive, I actually mean it. She is also an experienced family lawyer. She's a sought-after speaker. She's well-known in Christian education circles. So this webinar will be full of tips, good information, good advice. So I hope you will enjoy this. My name is Nikolai, by the way. Sorry, I should have said that at the beginning. Couple of housekeeping things in mind. If you have any questions for Fiona, you can ask them at the end of the webinar. I mean, you can type them in the questions tab. You see it on your screen, but she will be able to answer them at the end of the webinar when the webinar is finished. We will come back to questions, and if there are any questions, we will attempt to answer them in question time. After the webinar ends, you will receive email from us with a link to webinar recording. So you can play it later or maybe even share it with your friends. And this webinar will be available online. So I will pass the microphone now to Fiona and let's begin the webinar. Thank you.
Okay, thanks everyone. It's lovely to be here with you this morning. If you have any questions along the way, we will try and deal with them at the end, and I will try and make sure that there is some time for questions. In terms of today, for those of you who are aware of Corn Inland, we are a medium-sized law firm based in Brisbane, but we certainly do work all across Australia, and I've got schools as far away as Perth that I advise on a regular basis. Depending on what's required, our lawyers do travel to you if needed. We have a very extensive range of practice areas within the firm at this point in time. I've put there some of the reasons why you should listen to me in terms of I've got some degrees and qualifications. I've been in practice 14 years now, including 5 years at Legal Aid Queensland, and I'm currently working in the commercial team doing complex matters for schools and not-for-profits. Because I've represented private schools in some fairly complex general litigation matters, I've seen what can go wrong from a litigation side of the fence, and I'm passionate about helping schools to apply an ounce of prevention rather than having to deal with fixing the problems later. One of the things that it's important to look at is enrolment. For schools, enrolment is sometimes seen as just a process to get kids in the door and to allocate kids to classes and make sure we've got enough students and enough teachers and everything's going to work well. It's a legal process at its heart, though, that sometimes schools don't think about until things go horribly wrong. And it's a process that really has many opportunities to try and head problems off at the pass. So it's not just an issue about what your contract says, but it's about the process that you go through before you enter into a contract with a family to provide educational services. When you boil it down from a legal perspective, what we're really looking at is a process where a school is entering into a legal contract to provide services in terms of educating a child in exchange for money. Now, obviously, depending on the school, that money aspect, generally speaking, it's a not-for-profit, so you're not looking at making profit out of it, but you are needing funds to be able to pay staff and to build buildings and provide the services generally. That sounds all pretty mercenary and all pretty, basically it's a financial transaction, but that process and that contract that you're entering into is really the starting point of running a marathon with a family. And that marathon will hopefully go over the life of the education of their child. So, for example, sometimes you're starting off with kids in prep who you will still have in your school in grade 12. And that's a wonderful opportunity and a wonderful challenge. But the contract process itself is really the start line. And sometimes people lose sight of the fact that if you get things right at the start, sometimes you can win the race on how the start goes. In terms of enrolment opportunities, the enrolment process is an opportunity to gather relevant information. That's really important because sometimes, particularly when you're dealing with kids, it's really important to make sure that the people that you are in fact entering into a contract with are the people who have the ability to enter into a contract about the child. So you need to make sure that the right people are part of that contract. You need to make sure that you're using the enrolment process to screen families and children and make sure that you can offer the educational services that you say you will. That's an opportunity to figure out whether or not families are a good fit, whether or not if a child needs additional supports, whether or not the school has the ability to offer those extra supports, and whether or not in the big scheme of things it's a fit that overall will work. It's also that enrolment process is an opportunity to set out boundaries and expectations that the school has of parents and of students at the outset. You would, I suspect, all have come across situations where parents, for example, have come in and said, look, our expectation is significantly lower than your expectation, and so I would like you to stop doing X, Y, and Z. The one that comes to mind at this point in time, and it's one that's been topical in some of the, particularly on the ABC of late, is homework. So there is a growing group of parents who are against kids having to do homework, and will often say, well, no, I don't support that, and on that basis my child won't be doing homework. Obviously that is at odds with some of the school's expectations in terms of homework, and so it's important to set out those boundaries and expectations at the beginning so that it's not a surprise to parents and it's not a surprise to kids. It's also about making sure that the expectations that parents have of your school is a good fit. Because, for example, if parents have certain expectations in relation to what they can get from your school or your college in terms of learning experiences, and you don't deliver on that, that's going to be a point of conflict. So it's important that parents understand what you can offer as well. It's really about starting a relationship with a family on a good note. It's nothing more complicated than that in many respects. In terms of the enrolment contract, that's an opportunity to make sure that everyone understands the deal that they've reached in terms of what the school is going to do, what the parents are going to do, and what the benefit is. It also tries to head off common problems before they occur. One of my colleagues, and we'll talk a bit at the end about different services that Corny and Lind offers, but one of my colleagues has got a fairly streamlined and low-cost debt recovery process that we can sometimes offer for clients. And the problem really comes in terms of enrolment contracts from time to time when you look at the enrolment contract, and the enrolment contract actually doesn't clearly say that we're going to issue fees and you're going to pay them, or when you're going to pay them. And so some of those common problems arise when contracts haven't been reviewed recently. A number one concern for many of my clients at this point in time is, what do we do with parents engaging in social media? Because sometimes their social media use is really very unhelpful, and how do we manage that? So it's important to use the enrolment contract to look at those sorts of things, to make sure that the expectations in terms of that your parents are going to treat each other and staff and other students and people in the school community respectfully and will refrain from bullying and abusive or aggressive behaviours. Those are sorts of things that should be clear in the enrolment contract, and to give you the ability to say, well, no, this is the standard that you agreed to and you need to comply with that standard. It also is designed to give schools options in terms of dealing with things if problems occur. So just as getting into a relationship is a very important thing, so is getting out of the relationship. So we're going to go back a little bit to Contract Law 101, and that's because at the heart we're talking about a contract. So in order for there to be a contract, we have to have a number of things. So we have to have offer, acceptance, an intention to create a legal relationship. We have to have consideration, legal capacity, and consent in terms of the contract and contracting parties. Now, I want to talk a little bit about an offer versus what we call in law as an invitation to treat. So an offer is effectively, here is a deal I'd like to do with you. Will you accept it? It's different from a willingness to deal with someone or a willingness to negotiate, as in, look, I'm interested in exploring doing a deal with you, as opposed to here is the deal. An offer is really a promise to be bound by a contract if the terms are accepted. So, for example, we are happy to enrol your child on these terms. Here are our terms. We'll be bound by that if you sign it and return it to us within a couple of weeks. You can withdraw an offer that's made, but you can only do that before it's accepted, and you have to communicate to the other person that the offer has been withdrawn. So if you change your mind or something happens, you can do that, but you do need to be aware that if they accept in the meantime, you can't withdraw. The difference with that invitation to treat phrase is a phrase that's been around for hundreds of years, and it was started by some English court judges many, many years ago. And the usual invitation to treat is, a product in a store with a price tag. So in some circumstances, it would be considered an invitation to someone to make an offer to purchase it. There aren't any terms stated, just a price listed. And so effectively, by taking it to the cash register and saying, I would like to purchase this item, and I understand it's got a warranty or whatever, and here is the money. When they accept that money, effectively you're making the offer and they accept it when they take your money. There are good reasons to make sure that your enrolment process is structured so that applications for enrolment are the offer. But this is something that you need to have a think about it, and it does actually require some legal thought about how you want that to be structured and why. So, for example, if you are looking at doing your contracts 2 years in advance, the considerations are different when you're looking at when you want to be bound and when you don't. So you do need to make sure also that your policy and marketing materials and contract documents work together. So your enrolment process and enrolment policy documents have to work with your enrolment contract. There's a rule called the parole evidence rule, and I promise it doesn't have anything to do with getting let out of jail, but it talks about if it's not clear in a contract what something is or what something means, then you can have regard to the other documents that surround that. So things like marketing materials and policy documents. So it really is important, if you want your contract to stand and if there's any ambiguity, that those documents all work together. In terms of acceptance and intention to be legally bound, usually someone agrees to an offer. Sometimes that's by statement, so sending an email saying, I accept your offer. Sometimes it's by signing a written contract or by their action in just going ahead and behaving like the contract is on foot. You can't accept an offer just because you haven't rejected it in most cases. The tiny print at the entrance to a paid parking facility might suggest that that's the case. And you can do it, but you have to do it in a certain way. So it has to be drawn to the attention of someone. They have to have the ability to accept or reject it. writing something in tiny, tiny font and saying, if you don't email me back within 20 minutes, then you've accepted the offer, is really it's not going to cut it. So there are some rules around that, but it's largely an area based on common law, not contract law, not legislation. And so as a result of that, it's not easily found if you are not working with contracts on a regular basis. The other thing that we need for a contract is someone to be actually entering into that contract on the basis that they intend it to be binding. This is not always explicit. So sometimes people go, oh, yeah, but I didn't expect that I'd have to comply with that. That's one of the reasons why I recommend that when you do your contracts specifically say this is a legally binding document. This is a contract and you are going to be expected to be meeting the terms of that contract, because it's important for people to actually know what they're signing, but it's also important for them to understand that it actually is serious. The consideration section is the section, obviously, that most of the account staff are interested in. This is a fancy Old English judge way of saying the price paid or something of value. So with this sort of arrangement, what we see is that sometimes, more often than not, it's you'll pay us this amount of money. But some of it could be money, some of it could be part volunteering, special skills or experience. It actually doesn't matter what the value is, as long as some sort of value changes hands effectively. Even a barter will be considered to be consideration from a court perspective. I have seen schools, for example, in very limited circumstances where a parent has genuinely wanted their child to go to that particular school, but they also genuinely couldn't afford it. Enter into arrangements, for example, that said, all right, well, you've run a cafe in a former life, so how about we deal with it on the basis that you run the tuck shop on the 2 days of the week that the tuck shop runs. Obviously, you'll be supported by other volunteers, but you run it. You organise all of the stuff behind it, and we'll consider that as payment for your kids' school enrolment. Those sorts of things don't happen often, but they do happen from time to time. And so it's important that you understand that even if that happens, you do have the consideration, and therefore the contract will still apply. So the next one is legal capacity and consent. So not everyone can enter into a contract. So, for example, people who have an impairment, such as an intellectual impairment, for example, that might have resulted in them having a guardian. Young people or children effectively can't enter into a contract in most cases. There are some exceptions to that rule. Some categories of prisoners. So usually it's prisoners who are serving a sentence longer than, I think it's 18 months now, but I'd have to check that. And of course, my dog, for those of you, just to make sure everyone's awake still, my dog, there's a picture there, cannot enter into a contract. She does not have legal capacity. Consent has to be genuine. You can't force someone to sign a contract, because if you do, it won't be binding. It's the contract law equivalent of the shotgun wedding. So proper consent can be affected by mistakes, false statements, duress, and undue influence or unconscionability. Unconscionability and undue influence are concepts that we normally see in what used to be the old Trade Practices Act, but it's generally consumer protection. It is the sorts of things that we used to see arguments about in terms of the banks and their bad behaviour. And in fact, the leading case in relation to unconscionability was the Commonwealth Bank, as I recall, and Amadio. And that case has been around for 100 years, but well, I probably exaggerate, but many, many years. But the short version is that if you take advantage of someone, then there arguably is no contract. You need to know who the contracting parties are. So you need to make sure that the people who are actually entering into these contracts are the right people. And we'll talk about the family law aspects about that in a moment. But the short version is that if a parent has not got parental responsibility for a child, they shouldn't be signing the enrolment contract because they actually don't have the legal ability to make a decision for their child in those circumstances. The other thing is it's really important to have terms to the contract. So if the terms of your contract are solely, I've ticked the box to say that I've read the policies of the school, there really aren't any express terms of contract. And there are some schools around that still do that. It's a really big problem because technically on that basis, you don't have a contractual basis to recover your school fees. You don't have a contractual basis to say, well, we're going to suspend your child if they try and murder someone at the school. You don't have a contractual basis to do anything because there are no express terms. It's really important that your terms and conditions document clearly set out in writing the terms of the contract. Implied terms can happen at law. They're usually terms that are not written down or discussed, but they have to be, they can only be implied by a court where they are necessary to make a contract work. So if the contract can work without them, then they won't be implied. So what I mean by that is it would probably be an implied term of an enrolment contract that a school was accredited as a school, even if that wasn't a written down term of a contract. But if the term that you are trying to imply is that you're going to educate the child to the best of your ability and they're going to pay you, that would be very different. If there isn't an express term that says that, then you may not have the ability to enforce being paid. In terms of implying terms, it's very unusual to successfully argue that those terms are implied. And so you need to really be putting down your express terms as much as possible. The other thing to remember with this is, this is probably a non-legal anecdote to some degree, but I still recall sitting down with some very, very successful businessmen Christian blokes who said to me, I said to them, how do you manage these big contracts? And the very clear advice they gave me was, well, we're all mates and we do deals and all of that sort of stuff. And I know the people I'm working with, and often we'll start with negotiating and a handshake. But before too long, we always reduce it to writing so that it's clear what one person is going to do and what they can expect of the other. Because then if there's ever a dispute, you can go back to the contract and you can go, oh, yeah, that's what you said you were going to do and that's what I was going to do. So, okay, let's just get on with it. And so that contract process and the process of putting pen to paper is really very helpful while things are amicable and before the relationship breaks down, at trying to minimise the level of conflict that you have later in the piece. So it's really important that you look at putting in express terms. The other thing that I've seen lately is and to be fair, a lot of schools are using the same template. I'm not sure where it's come from, but the same sorts of phrases are turning up. I'm seeing a lot of fairly short enrolment contracts, so 2-3 pages. And the problem is that those enrolment contracts probably don't meet the current needs of most schools. They don't set out clearly enough what the expectations are and what parents have to do and what we're going to do for that money. So it's important that you get your terms right. It does need to be readable. But of course, the other thing to remember when you're looking at these sorts of things is that contracts which are written largely in plain English are also contracts that tend to be a little bit longer because you can't use the terms of trade, so to speak, and the shorthand that we might otherwise use in contracts. And it's important that you don't in these enrolment contracts, because enrolment contracts need to be workable and they need to be usable. there's no point having an enrolment contract that's written in such a way that your account staff and your registrar can't figure out what it means. And there's absolutely no point having an enrolment contract that parents don't understand either. So it's important that you take the legalese out as much as you can. There are some things that need to be in there that will just need to, of necessity, have legal language. But to the extent you can, try and write your contracts so that they're understandable. My favourite anecdote, really, when I'm talking to young lawyers who are drafting, is to say to them, well, this is a great piece of drafting, because often it is. It's excellent work. But you're using a lot of words that some people won't necessarily understand. So the test should be when you're writing something, you write for your audience. And sometimes I'll say to my young lawyers here, it's important that you write, for example, at a level that would be understood by your mates if you were having a quiet drink on a Saturday afternoon around the barbecue. If they don't understand that, then it's quite possible that the people who are using the documents might not understand it either. And you need to have a think about whether or not you're writing for your audience. Okay, so we'll head into everyone's favourite topic, and that's family law for schools. Now, if you were all in the room with me, I'd ask for a show of hands about how many people wish that families just wouldn't separate, on the basis that it would be a whole lot easier for schools to manage. And I suspect that most people around the table might well put your hand up. In terms of family law, when you're doing enrolments, there are some basic documents you really need to see. So the first thing you need to see is what your parenting arrangements are. If the parents are still living together and are still in a relationship, it's actually relatively straightforward. Both parents have parental responsibility, and either or both can sign your documents. That's really easy. If they're separated, then you need to have a look at some further documents. So the sorts of documents that you would want to see are either informal written agreements. They don't happen all that often anymore, and the reason for that is because we have parenting plans. Parenting plans are recognised under the Family Law Act as being a specific exception to court orders. But basically, at its heart, they're a document that writes down how parents are going to manage kids in terms of where they're going to live, what they're going to do, all of that sort of stuff. And the requirement is that it be written down, signed and dated by both parents. If you have something that looks like it's about kids, it's written, it's signed and it's dated by both parents, then you have a parenting plan. It does not have to have parenting plan written across the top of it, although many of them do. But if it's signed in writing and dated, that's sufficient. The next thing you might see is court orders. Now, you'll see in the right-hand side, I've put one of the court seals there. And what you're basically looking for is a document that has that sort of seal on it. Sometimes sometimes parents will give you the unsealed copy. Always ask for the sealed copy. It is possible, but it's beyond the scope of today's discussion, that there could be orders made by a court exercising child protection jurisdiction. So that's things like kids are in the care of the Department of Child Safety in your state, or are under the other option is that kids are under the guardianship of someone other than a parent in circumstances where parents have passed away and other family and friends have been appointed by a will. Those are the sorts of documents you're looking for to start with. And really the question you want to know is who has parental responsibility for this child? So Section 61B of the Family Law Act says that parental responsibility in relation to a child means all the usual duties, powers, responsibilities and authority which by law parents have in relation to children. So basically, the power and the responsibility to enter into contracts with schools for the purposes of educating their children. When you look at the court orders in particular, and it needs to be court orders, generally speaking, because if there are no court orders, then parenting plans actually don't have the ability to displace a parent's parental responsibility under the Act. It's a little known thing, but it is an important one to note. So if one parent has sole parental responsibility, then they give permission. They sign the they sign the enrolment documents. And you probably need their permission to disclose information to the other parent in some circumstances. So you need to read the order and see what it says. And you probably need to have a discussion with that parent about, okay, what's the issues here and what do we need to know? The big red flag is that, generally speaking, if one parent has sole parental responsibility, there is a problem. The reason I say that is because the clear preference, and it's a reflection of our obligations under the United Nations Convention on the Rights of the Child, is that it is usually best for parents or for children if both parents are engaged in the decision-making process and are involved in parenting. So if there is a court order that one parent has sole parental responsibility, that's probably a red flag to say there's a problem there somewhere, and you should be asking some further questions to make sure that you can fit your processes to ensure the safety and well-being of the child. So you probably need some permission to disclose in those circumstances, but have a look at it, and when in doubt, ask the question. The other trick to note is that, and I haven't looked at them recently, but some of the funding agreements pursuant to the Schools Assistance Act used to have a requirement that schools provide report cards to both parents. Now, the section 425 in Queensland of the Education General Provisions Act might be your escape clause. And that clause has been amended over I think probably 12 months ago now, but I'd have to check. And that now allows principals to make a determination that for whatever reason, it's not appropriate to send report cards to both parents. And on that basis, you might be able to avoid that obligation. If it comes up, please get some advice about that, because it does change and we'd need to have a look at the funding agreements again. But it is an issue to be aware of. If you've got parents who have equal shared parental responsibility, the very first point there is the most important thing I want schools to take from this. And that is, you are entitled to act on the direction of one of the parents as if it was a joint decision, unless you know it's not. The reason that's important is because if a parent gives consent, for example, for a child to be administered Panadol, or a parent gives consent for a child to go on an excursion, you don't have to get the consent of both parents if there's equal shared parental responsibility. You can just work on the basis that that parent has obtained that consent effectively, and that they speak on behalf of both parents. Obviously, that doesn't apply if you know that the parents are not in agreement, but otherwise you can act on the direction of one parent. Ideally, I'd like to see schools sharing information with both parents wherever possible, and trying to get both parents to sign enrolment contracts and the big documents and come to an agreement together is useful. The reason for that is if you can get both parents committed and on board to start with, it makes it much easier to manage that relationship on the basis that you guys don't take sides, you are there to educate the child, and that you'll communicate equally with both parents and take instructions from both parents. It's really important to stay as neutral as possible in these sorts of situations, because it does reduce the possibility for conflict later. You do need to make sure that your enrolment contract deals with what happens if parents change their mind. The reason I say that is because we have seen in the past, unfortunately, some significant litigation that came out of a parent who determined that they did not want the child to continue going to the private school, primarily, I suspect, because they did not want to pay the school fees / child support that flowed from that decision. The difficulty was that because the contract really didn't deal with what do we do if parents don't agree after you separate, then there were all sorts of issues in terms of trying to figure that out, and it ended up being a huge conflict. So, who has parental responsibility and why do we care for contracts? We care because if there are no orders or the orders don't make mention of parental responsibility, then both parents have parental responsibility and either can sign your contract or both. You do need to have a think about what happens if they don't agree later on. If there is equal shared parental responsibility, you can act at the direction of one parent on the basis that they speak effectively for both. You're better to get both parents to sign if you can for your enrolment contracts. But even if there are equal shared parental responsibility, if there are allegations of family violence or there become allegations of family violence, you still need to consider what your communication strategies are. And those sorts of things should be in your contract. It should be the case that there are arrangements in place that say there are opportunities for us and we can sometimes communicate with one or other of you, and it's your responsibility to share that information. So, for example, if you're sending notes home with kids in school bags, and this is often a problem for primary schools in particular, it should be a responsibility that the parents are actually communicating with each other on that you don't have to send home 2 sets of notes, just 2 different households, for example, that you send 1 set of notes home and you put it on the parents to communicate with each other about the children's needs from there. So, some big picture tips in terms of what you should consider putting in your enrolment contract, and some things that you can have a think about. So the first thing that you want in your enrolment contract is confirmation that during that process they've completed the application forms correctly and they've made full disclosure. They haven't given you half of the picture. It's also, following on from that, it's actually also important that you make sure that they are required to continue to provide you with accurate information and full information in relation to the child. And that information is really used for you to be able to provide education to the child. So it's about making sure that if the child has been ascertained, if the child has got a suspected learning difficulty or has a hearing difficulty, that those assessments can be made, that arrangements can be made, for example, for hearing loops and things like that to happen in the classroom if the child needs that. If they don't tell you, you can't make those things happen and you can't assess whether or not you can provide the reasonable adjustments that a child needs. So it's really very critical that they provide you with accurate information, and it's critical that they continue to provide you with information basically from the time they first contact you right through until the child leaves school. That needs to be a contractual requirement. It needs to be clear that that is an expectation. It's important that parents support the school ethos and approach, statement of faith where there is one. In terms of those sorts of things, it's really helpful to get them to buy in at the beginning, because you have much less problems at that point when they come and say, well, my child doesn't want to go to chapel. And the response is, well, I understand that your child doesn't want to go to chapel. They probably don't want to go to maths either, but you said you would support the school ethos and approach and statement of faith. And what that means is that chapel is in fact part of the school ethos, approach and statement of faith, and the child has to go. Be clearly setting out what you're responsible for and what parents are responsible for. So if you're responsible for providing all of the books, but the parents are responsible for making sure that all of the books are returned, then put that in there. If the expectation is that parents will have to pay the replacement costs of library books, textbooks, school laptops or other devices, if they are not returned or they are returned in poor condition, then it needs to be in there so that parents know what they're potentially responsible for. You need to set out behavioural expectations of students, because ultimately what you need is that you need the parents to buy in to a commitment to, yes, these are the expectations that the school is going to have of my child, and I will support the school in that. It is important to include, for example, in my view, that if the behavioural expectations are not met, there are going to be consequences, and some of those consequences may include afternoon detentions. They might include internal or external suspensions. They might include the child being expelled from the college. The reason that's important is because those are all things that parents are going to have to actually manage. If you give a child an after-school detention, that means they can't get on their usual bus. A parent is actually going to have to come and get them. What that really means is that you need to make sure parents are going to be aware that that is an expectation. The other thing that's coming up quite a lot is behavioural expectations for parents. Now, once upon a time, if you had have said to me, our big problem is parents behaving badly, I would have been quite surprised about that. It turns out that over the years, we've had increasing parental combat, really, towards schools. And as recently as 2 days ago, I saw that there was a fairly extensive article in, I think it was a News Limited publication, about the frequency with which schools and school staff are threatened with violence by parents. It's not acceptable. It is actually a workplace health and safety issue for schools, quite apart from the fact that you have a parent who might become a physical danger to someone. You have obligations in terms of workplace health and safety to your staff, not just physically, but also in respect of their psychological health. If they are going to be continually exposed to angry, aggressive people who are not pulled into line, who are not told your behaviour is unacceptable, then you are likely to find that you are going to have staff who are under a psychological disability, either temporarily or permanently, and that is a workplace health and safety issue. It's also just not acceptable behaviour. We see temper tantrums in small children, for example, and it's not acceptable for them, but it's terribly unacceptable for an adult to have that sort of temper tantrum. And so it's important, I think, to set out those behavioural expectations, and not only to set them out, but to follow through with them. It's not okay for parents to send angry and abusive emails and text messages and communications generally. And it is important to be able to pull them in for a meeting and say, okay, let's talk about this. Clearly you're upset. Let's talk about it. Let's hear from you what the issue is, deal with the issue, and then say, now can I talk to you about the issues we have? And those issues are our expectations in terms of your behaviour, as set out in our contract, are that you will behave with respect, that you will not be aggressive or abusive towards staff, and in this case, you've not met our behavioural expectations. So, big picture going forward, can we commit that this is not going to happen again? If it does happen again, then these are the consequences that are going to apply. You also need to include provisions about what happens if parents don't agree, usually after separation. We've talked a bit about that. The importance of that is because what the law is in terms of family law and what the law is in terms of contract law about who can sign contracts for kids is actually different. The two don't talk nicely, okay? It's like having competing software, I suspect, when the two don't talk. So it's really very important that you make sure in your contracts that you spell out what's going to happen, because it's not easy to simply rely on the family law because it just doesn't work from a contract point of view. You need to set out how you're going to deal with information that you receive from parents and how you're going to deal with information you provide to parents and others. It includes it should include provisions requiring parents to provide the schools with copies of family law orders and domestic violence orders and advising if things change. That's normally not a problem. Most people are already doing that. And you can be sure that if a parent has got the benefit of a parenting order in their favour, that they'll be down on your doorstep with a copy of it fairly shortly after receiving it. In terms of communication arrangements, you need to consider social media use. That is the big hot topic at the moment in terms of how do we protect ourselves from a parent who wants to misuse social media, either towards other parents or in respect of making comments adversely about staff and about the school generally. It's important to have clear arrangements about your payment of fees, when you're going to issue the invoices, how they're going to be paid, whether it's going to be BPay, credit card, direct deposit, all of those sorts of things, and what the consequences are if the payments are not on time. You must be able to terminate your contracts if fees remain outstanding. Privacy issues are an increasing issue. They are an issue that is becoming more and more prevalent. It's important that your enrolment contracts make clear, are you going to store the students' data in the cloud, for example? Have you got appropriate arrangements in place to lock down and make sure that privacy implications are taken care of? The final thing that I like to put in enrolment contracts is to make sure that your termination options for if things go wrong are in there. So some general traps, what icebergs we want to try and avoid. We don't want to be like the Titanic and be at the bottom of the ocean. First problem, school policies. There are two ways of doing it. I've seen many schools incorporate school policies as a term of the contract. The problem with doing that is if you incorporate them as a term of the contract, you're bound by them. And what happens is if a staff member then breaches a policy and a parent complains, you're potentially dealing with a breach of contract claim, because the policy is part of the contract. You've breached the policy, therefore you've breached the contract, and the parent says, well, you've breached the contract and I'm not happy. Avoid incorporating school policies as terms if you can help it. In terms of anti-discrimination, increasingly schools are finding themselves responding to allegations of discrimination, usually on the basis of sexuality or gender, religion and impairments. And by impairments, we talk about things like autistic spectrum disorder, medical issues basically. Autism is a big one, but it's not the only one. Mental health problems is one of the others. Your enrolment process and policy is really important in the discrimination space. It's important to set out what you do to avoid discrimination. We're not going to talk about discrimination because that's a whole topic in itself, and it's well beyond the scope of today, but it is an important consideration. And if you haven't done much work in that space, it's important that you do go and talk to someone about that. Domestic violence is one of my pet topics. For those of you who have heard me speak, I do try and talk about domestic violence whenever I can in this context. The reason I say that is because schools are really frontline and you have the opportunity to affect change. I saw a professional development session earlier this week, and what it said was that in Australia at the moment we have 2 women a week who are being murdered as a result of domestic violence. And it is the single most preventable category of violence. We almost certainly know when it's coming. We have the tools at this point in time to assess when something is high risk. It's important for schools, if you have parents coming to you saying, I'm the victim of domestic violence, that you do refer them for specialist intervention and support and assistance as required. But it's also important that your enrolment contracts require that parents provide all copies of DV orders that apply. You need to keep a copy on the file. you need to have a look at those. Sometimes kids are named on those orders, and sometimes there are specific orders that say, for example, that a parent cannot come and have contact with or come within 100 metres of that child unless family law exceptions apply. From a school's point of view, you generally speaking would not know unless if the exceptions apply. So if a parent turns up and approaches a child in those circumstances, they are possibly breaching an order and engaging in a criminal act, and you should probably call the police. You need to ensure that communication protocols are in place and all staff are aware of the issues. One of the key issues is how you manage your portals. If you have portals, to make sure that, for example, it's not one login for the family, because if the family separates and one parent is engaging in domestic violence, of course, one of the things that happens is that the victim of domestic violence or the aggrieved may well log in and change their address and contact details once they move to a safe place. If that portal information is available to both parents, then the alleged perpetrator of domestic violence can all of a sudden see where the person is, and it may compromise their safety. You also need to think about making sure that when emails go out to, for example, the parents of a class, that arrangements are made so that parents can't see each other's email addresses, that separate emails are sent in circumstances where there's domestic violence issues. Make sure you get some advice. If there's a conflict between your safety issues relating to domestic violence and family court orders and your funding agreements in terms of providing school report cards, or if there are just problems generally being on with parents being on the schoolyard, get some advice and ask some questions about that. Social media, I've talked a little bit about this, but parents are increasingly using social media as a coercive tool. A stick rather than a carrot, so to speak. So they will often get on and say what a terrible person this particular staff member is, or what a terrible school this is because they did this, that and the other. It's important to be all over that stuff because unfortunately mud sticks, and in the digital age people are actually looking at those sorts of things, and they're looking at the Google reviews and the like. So be on top of that. One of the tips I often give schools is that if you're going to have Facebook groups, for example, for the Year 7 parents group, that it's important that the school has the ability to moderate that and to remove offensive posts and things like that, because what you don't want is to be held liable for something that you didn't have a whole lot of control over. Those sorts of things should be covered in your enrolment contract and often aren't. So where to from here? I want to talk a little bit about your action plan. This advice is the school equivalent of what I tell people to do with their wills. And that is, every year you need to be pulling out your enrolment process and policy and your contracts and read them. And what you're reading for is what's tripped us up in the last 12 months. What have we got that needs to be amended? What are the legislation bits that might feed into this that have changed? What have our policy and process have changed? If you've gone from a paper-based enrolment system to an online system, for example, that's a fairly massive change, and you should be updating your policy and your process and your contracts accordingly. So pull them out and read them. I would generally say to people, look, pick a fixed time, whether it's the end of June. That's often a problem for account staff, but pick a time in, say, September each year to pull it out, read it, and then gather your team. It's really important that all of the people who have something to say about this are part of it. I've met with a number of schools over the years in terms of reviewing your enrolments, and what I really like to do is pull together the enrolments registrar, the principal or deputy, someone from the pastoral care team, someone from the accounts team or the business manager. Because if you can get people from those 4 areas of the school in the same room together, invariably they all have a slightly different perspective, and they will be able to say, okay, well, it's fallen down in this area this year. This is the problem we're having. We're chasing debts. We're having this issue. We've got parents who won't give us copies of their court orders. And so you can talk through as a team the issues that you've had. Consider setting up your documents and procedures that allow for easy updating of terms. One of the things for schools is that obviously if you update your terms every year, you could end up with a number of different contract terms across the school. What I would encourage you to do, there are some really nifty ways of allowing you to update things on an ongoing basis. It is a bit technical from a legal perspective, so I haven't gone into it now, but it is something you can do. So you can update the terms by notice and effectively get parents to accept that way. What it does mean is that from the time you implement that moving forward, you can effectively start to standardise the terms and conditions in your contract. So when you ring me and say, hey, we've got a problem with this family, and I say, great, can I have a copy of your terms and conditions of the enrolment contract they sign? You can go, oh, yeah, well, they're on the current enrolment contract terms and conditions. Here it is. So that comes to the end of the substantive part. While you're typing your questions for me, I'm just letting you know that we've got our next school webinar is on the Friday the 24th of May at 10 o'clock Brisbane time, and that's talking about whether your school is compliant when it comes to government funding. If you'd like to register to that, you can do that on our website. The next one is we do offer a free school health check. That's usually a short 45-minute consultation or conversation with one of our senior lawyers. I really love doing that because it means I can go out and see your school, and sometimes laying eyes on the school and understanding the layout of it is really helpful. That's only for Brisbane area. Regional and interstate, we can do it, but we'd need to talk about whether or not we do that remotely or whether we travel for that. We also do enrolment contract reviews as a fixed fee package. That's some of what I've been working on. And so it starts with an initial consultation with your team. And I like to have the various different sections of the team as part of that. I then look at the enrolment contract. We can either rewrite it or amend it depending on what needs to happen. We also look at the enrolment process and your enrolment policy as part of that. So it's not just the review of the contract, it's the whole package in that. And we do have a fixed fee offering so that schools know what they're going to be incurring in costs. We also do some tailored CPD presentations. So I will often go out and talk to schools and do their in-house training for their team about child protection, workplace health and safety, managing enrolment contracts, family law, all of that sort of stuff. That is, again, a fixed fee arrangement. It involves 2 hours at your school, including Q&A. We do, generally speaking, provide slides and sometimes papers, depending on the need as well. And again, that's for Brisbane schools primarily, but we can talk about travel for some others if you wish. The final service that I just wanted to highlight for you is that we do have fixed cost debt recovery matters that we do, where we can send out letters of demand and start that process for you as well. So we'll just flick back to questions in a minute and see whether there are any questions that I need to answer. Okay, so the first question I've got is the impairment aspect of contracts. So I assume that that question is in relation to the issue of discrimination from a disability point of view. If that's the case, yes, it's a whole different ballgame, frankly, and it's a big issue that's probably beyond the scope of today. But it's one of the reasons why we recommend that you have the conversation with people and get people in and do an interview before you actually offer them an enrolment opportunity. It's one of the reasons, it's something that I can certainly talk to you offline about if you've got some concerns about it, but that's really part of your process and getting your process right. Okay. In terms of jointly and severally liable, the short version is that I'm not entirely sure that there's, yes, you can rephrase it so that it's clear that they are liable both together or on their own. It's a term of phrase that's reasonably widespread. So it's one of the few that I would say it's questionable whether you'd want to make that plain English. I'd prefer to make it plain English if we can. And it to some degree, it depends on your parent group as to how far you want to go with that. In terms of newly updated terms and conditions, so changing those, it's not so easy as simply to inform parents that you've changed those conditions and ask them to accept. The difficulty with that arrangement is that if your contract doesn't currently allow it, they don't have to change the contract. They don't have to accept it. And if they don't accept it, then you really can't do anything about changing it or terminating. You're stuck with what is there. So there are some ways and means of doing it, but there are also some risks associated with that. And so if you're looking at doing that, I would suggest that you do get some legal advice quite separately from this, because there are some risks around unfair contracts and unfair contract terms from a consumer protection point of view, and undue influence as well. And whether or not it would be effective to do it that way would really depend on the terms of your contracts. Okay, so we've got another question about a family with a domestic violence order in place where a parent wasn't allowed within 50 metres of the school grounds, but the other parent emailed and said they'd given written permission for the father to collect the child. The short version is the terms of the domestic violence order will determine whether or not that's acceptable. If the domestic violence order has an exception, and we call it a family law exception, but basically it's an exception in circumstances where there's an agreement or something in writing or a court order, then sometimes written permission from the aggrieved parent is sufficient, but it really depends on the terms of the domestic violence order. The other thing I just want to pick up with that is that you don't, as a school, you don't have to comply with the domestic violence order. You have to, and you don't have to ensure the compliance by everyone else. Unless a school is served with a copy of an application or given an opportunity to attend and be heard on any order that a court is made, technically the court has no power to bind you to do various things. So it's not that you have to comply with a domestic violence order, it's the other parent, and it's really a matter for them about that. I would recommend that you refer the parents both off for legal advice about those matters, though, because there's some curly parts attached to that are more problematic. Okay, I think, and we'll just double check that that's the last of the questions. Yep, that's the last of the questions. So thank you very much for joining us today. If you've got any issues that you need some further advice on, please feel free to call us. We do try and answer schools within the same business day where we can. Obviously, if it's a bigger issue, then it might take us a bit longer to resolve the problem. As I said, we do have some upcoming webinars and we do have some fixed fee offerings specifically designed for schools. So if you've got any questions, please give our office a call. Thanks for joining us.
Bye.